Lord Justice Archer, representing the Chief Justice. Dr. Anthony Insiasari, Presidential Advisor on Health. Representative of the Director of the Ghana Health Service. All other protocols observed. The very first lawsuit that I brought as a lawyer was against La Polyclinic, then called La Polyclinic. It was a case involving the detention of a formerly pregnant woman who had had a baby and who could not pay. Her failure to pay resulted in her detention together with the newly born baby, who therefore entered the world through a prison. After having been detained for 6 months without paying the fees for which she was supposed to have paid upon delivering, this woman had accumulated such debt that had made it even more impossible for her to pay and therefore for her to free herself from the clutches of the hospital. I was tasked by my senior in chambers to test this case as my very first assignment as a lawyer. First, young lawyers tend to have a lot of energy, so we do a lot of research. So upon conducting an extensive research, I came across a law passed in 1971, which was titled the Hospital Fees Act. And the Hospital Fees Act, which I will tell you, is still in force. And that's one thing we don't realize. There's so many books on Ghana's, there are so many laws, on Ghana's statute books, that if anyone cares to know, there are laws that protect us in different ways. The Hospital Fees Act contains a provision that says a certain group of people, including pregnant women and old people above the age of 70, were entitled to walk into any public medical facility, seek treatment, and walk free without paying. So upon bringing that law to the attention of the judge, I succeeded in getting this woman freed. And you should see the anger in the faces of the hospital administrators. Now, as I looked at them, as I walked out of the courtroom, I knew if there's one place I should never go whenever I was sick, it is the La Polyclinic. I think it became the La General Hospital. And you can be sure that my fear survived. And so I never ventured in that area because I'm sure my name and picture was displayed somewhere that if I entered that facility, I should not go back alive. The medical relationship is one that involves complicated rights and liabilities of all parties involved. Doctors have liabilities, patients have liabilities. Doctors have professional rights, and therefore when I say doctors, I mean all health carers. I use doctors as a main symbol, but health service providers have responsibilities and rights, and patients have their own responsibilities and rights. It will surprise you, however, that even though since 1993, we have operated a constitution that gives patients enormous rights long before the Patients' Charter was adopted, the relationship between medical practitioners and patients, many will describe as being abusive in character. Now, this is surprising given the fact that the medical establishment is supposed to be one of care. But often patients are the lower rungs in that arrangement, in which they are often subjected to treatments that are below the standards prevalent in other parts of the world. It is therefore a truism that the relationship is one that is seen as patrimonial. Patrimonial in the sense that one sees himself, and in this case, medical professionals see themselves as fathers or parents. And patients are often seen as children. In that relationship, parents know it all, children know nothing. And so often you will hear the expression, and this one did not originate from Ghana, this is an international expression. They say, "Trust me, for I am a doctor." That means your ignorance is good for you. A model patient is an ignorant one. A smart patient is often to be avoided, if not altogether shunned. And the reason is because a smart patient is seen as an assertive, troublesome patient. An ignorant patient who is submissive, who is quiet and who follows, one who doesn't challenge, and one who doesn't ask too many questions is a model patient. Rather ironically, that character of a patient is rather a danger to medical practitioners. But often medical practitioners see these ones as one to be courted. Now, the complexity of the medical professional liability globally therefore implies that doctors and all caregivers cannot continue to expose themselves unnecessarily to liability without suffering irreparable damage in financial and reputational terms. What medical caregivers do not know is that when a patient is quiet and is not asked questions and is not given the choice, the caregiver carries all the liability. On the other hand, where the caregiver educates, advises, leads, guides, and reposes confidence in the patient, for the patients to then guide the caregiver in the treatment process, the caregiver washes himself of all these potential dangers and liabilities. And it's unfortunate that in the reality of things, in the scheme of things, medical professionals in Ghana themselves, in many cases, wallow in the ignorance of that relationship. Now, the context of the state of Ghana's health infrastructure and systems further implies that patients are already at the peril of care deficit. And empowering the patient who's at the center of the medical establishment and practice is a veritable imperative of our time. And by this, what I mean is that the system already doesn't help doctors to perform or do their jobs well. Doctors are themselves fighting for an environment worthy of their reputation and standing in society. Arguably, they are the ones who spend the greatest number of years in school, 7 years, I think. And, probably closely followed by doctors and architects. And when they're out of school, they end up operating in an environment which is not conducive or which is not commensurate with the investment of time and pain and industry in their training. So one may ask at this stage, why patient rights and why should anyone care? Now, patient rights under Ghanaian law is not an isolated regime of law. It is a subset of the general rights of human beings to personal and bodily autonomy, and as a result of which, when a person submits himself to treatment, he ought to be given the best possible care. The human rights provisions of the constitutions are there for human beings. If patients are human beings, then it means patients are entitled to all the human rights. It's simple logic. Therefore, the Constitution of Ghana mentions a number of rights, some of which I'll mention very shortly, fundamental of which includes the right to privacy, and some of which has been mentioned by my Lord in his presentation. The right to confidentiality. Why should we care? Now, the essence, therefore, of the product of the principles of legitimate expectation applies in the context of medical professional and patient relationship, in respect of which when a patient submits himself to treatment, there are expectations on all sides. Expectation number one. A patient expects that when he submits himself to treatment at the hands of a doctor, the doctor will administer the best possible care. Number two, the best possible care administered may or may not include pain. Number three, that pain, when encountered or endured in the process of treatment, is for the purpose of a better happiness at the end. And therefore, number four, that expectation of treatment, which potentially may lead to a person being cured, may happen. If any of these expectations fail, one of the parties may be entitled to bring up a claim against the other. Now, I said one of the parties because the doctor is equally entitled to certain expectations, one of which includes the fact that when the patient sits in front of him, the patient will tell him all he needs to hear. The patient will not decide to edit a few things. And do not get me wrong, patients do that all the time. All of us do that all the time. You sit in front of a doctor, sometimes you're wondering whether you should mention it all for a variety of reasons. But why should we care about patients' rights? We should care because we are all potential patients. And I'm sure that everyone in this room may have been a patient at one time or the other in your life, even though some of us do not like to go to the hospital until we really have to go. Now, the reality of disease and affliction implies that we may all be subject to the medical establishment sometime during our lifetime. Even more so, when one looks at things from the perspective of the WTO's definition of health, we are inexorably led to accept the fact that we don't need to be sick in the traditional sense of the word to seek treatment. The WTO definition of health says that sickness is not only the absence of disease. What it means is that you may actually be sick without being sick. But I cannot proceed further without also adverting our minds to the fact that most caregivers are not the most fond of assertive patients, as I mentioned. For them, submissive and obedient patients are the best patients. An inquisitive one is to be avoided or tamed, perhaps even suppressed. Ghana is at the point of its development where this dynamic is quickly becoming a thing of the past. And we've all heard stories, some of which have dampened our spirits, others traumatized us as to whether we should visit the health establishment. People have gone to hospitals for treatment of one organ or limb and have had the wrong organ or limb decapitated, removed, excised, or cut off. People have therefore gone partially disabled. They have left these facilities fully disabled. People have gone to hospitals and have been pronounced dead simply because of pre-surgical procedures such as the administration of the anesthesia. And by standard medical practice, that should never happen. I have had patients, and I've actually had to sue the medical facility, whose name I won't mention at this stage, for a patient who had gone for a simple hernia procedure, simple because that was what the qualified, or rather medical experts subsequently testified, a hernia procedure, and ended up dying because the penile organ was fully mutilated by the time the procedure was over. These are things that will shock standard medical practitioners themselves, especially when they are testifying in court about how negligent medical treatment may have gone wrong. The onset of social media also implies that news of negligent medical malpractice these days spreads like wildfire, and the demand for accountability gains momentum once a patient decides to pursue his rights. Cosmetic surgeries, we've all heard lately, has led to deaths. People have gone to have portions of their bodies remodeled or changed in ways that will make them look better than they currently look. And they've ended up dying. As I indicated, wrongful amputations, all kinds of procedures that ordinarily by medical professional standards should not have resulted in deaths. People have died. Now, talk of developing and adopting a national patient charter, which is already in vogue, is one that should gain momentum in terms of spread. And this is where Isaac's body comes in. I have to commend you for your energy. I have been quite excited at the fact that you are pushing this agenda, which is one on the periphery. Part of the reason we may not be very much active as a people in suing medical practices are twofold. Partly blamable on the courts, my lord, respectfully, because judges are very slow to granting reliefs against medical doctors, and this is not Ghanaian judges, globally. Part of the reason is because of what is called the fear of the floodgates effect. Floodgates in the sense of, if we start allowing too much suits against doctors, Too many people are going to sue doctors because a lot of things happen in the hospital, some of which are not negligent necessarily, but people suffer and die in the process. And so too many people are going to sue doctors. And if too many people sue doctors, doctors are now going to adopt a defensive posture. And a defensive posture includes, if you are not sure, don't touch him. And don't touch him means, you rather let him die. If he has to die, don't touch him, and potentially he dies. Which then means that the virtue of sometimes medical adventurism, all of us are here today because sometimes they will experiment, borderline things. They are not quite sure. This thing may work 50%, 60%, but let's try it. And then it works. And by reason of that, we have a particular treatment moving forward. If you are not sure, they are not going to touch you. So even patients who may potentially survive, doctors will allow them perhaps just to survive on their own or die on their own if there's a risk of trying things that may not work. Courts are therefore slow in this process because they would not like medical doctors and medical caregivers to feel the siege or to be under siege. That siege mentality of society is waiting for us. Make a mistake and then they sue you. To avoid that prospects, doctors may become defensive and they'll recoil.